A domestic violence restraining order is a special type of restraining order against someone with whom you have a domestic relationship with. This includes those who you are married to, have children with, those who you have a familial relationship with, even in-laws, and also anyone with whom you live with. A domestic violence restraining order will give immediate and powerful protections for you. For instance, you can have this person immediately removed from your home. If you have children together, you can stop all visitation until the court has another hearing, which is generally about 3 weeks away. Along with that, the person cannot contact you in any way, shape, or form, electronically, by phone, or in person, or even through a third person. You are highly protected in the state of California when you apply for and receive a domestic violence restraining order. In California, the definition of domestic violence in obtaining a domestic violence restraining order goes well beyond physical contact or physical abuse. There are many other things that qualify as domestic violence: breaking things, throwing things, not allowing you to leave a room or leave a house during an argument, punching a hole in the wall, tracking you, tracking your car. Other forms of domestic violence are as simple as taking away a cell phone, taking away car keys. In California, domestic violence can be found where this person has abused your children or even your pets. Basically, any person who's trying to exert control over you or to use fear or force to control you qualifies as domestic violence. In California, domestic violence is so broadly defined that even financial control can be a reason to issue a domestic violence restraining order. When you apply for a domestic violence restraining order, any orders that are made are temporary orders. These orders generally last until your next court date, which is in the state of California about 3 weeks away. At the next court date, you are petitioning the court to make those orders permanent. That requires a trial where evidence is presented and a judge has to consider that evidence and decide whether or not domestic violence has occurred. When you apply for a domestic violence restraining order, the orders that you're requesting can be granted by the courts either fully, partially, or even denied until the next court appearance. Even if the orders you sought are denied, you will still have a chance in trial to prove that domestic violence has occurred and to obtain a permanent domestic violence restraining order. For victims of domestic violence, a domestic violence restraining order offers many protections. For most people, the most important protection is immediate removal of this person from your home. Along with that, they are to have no contact with you in any means, in person, by phone, text, or even through a third person. They may not come within 100 yards of your house, your place of employment, or your car. Another protection offered in a domestic violence restraining order is that the restrained party is required to immediately turn in their guns and ammunition to the sheriff or to a licensed gun dealer. A domestic violence restraining order is also the quickest way to obtain immediate child custody and child visitation orders. In order to obtain a domestic violence restraining order, you must first file specific paperwork that details the domestic violence, dates, times, and other pertinent information in order to have it granted temporarily. It is very important that you hire an attorney who understands what domestic violence is and knows how to lay this out in a very specific way so that the judge has the required information to issue that protection immediately in a temporary restraining order. In most cases, a judge makes the decision on whether or not to issue a temporary restraining order based solely on the paperwork. So making sure that the paperwork is filled out correctly and that the details are filled out correctly and specifically makes all the difference in whether or not your temporary restraining order will be granted. Getting temporary orders can be done in the same day that you file for a domestic violence restraining order. Just because a temporary restraining order has been granted does not mean that you will automatically be granted a permanent restraining order. The courts issue a court date, generally 3 weeks away, where evidence can be provided by both sides and must be provided in a way that satisfies to the judge that domestic violence has occurred. Knowing how to present that evidence, knowing the rules of evidence, can play a major factor as to whether or not permanent orders of protection are granted for you or against you. When a domestic violence restraining order is granted temporarily, it oftentimes immediately evicts the other person and gives immediate child custody rights to the parent who has sought the domestic violence. Domestic violence restraining orders are often abused. People will make false allegations of domestic violence solely for the purpose of getting the other party evicted immediately. Also, because immediate child custody orders will be given and generally the other parent will have no rights to the child, people will file allegations that just aren't true in order to get an upper hand in a child custody or child visitation case. If you find this video helpful and have any questions, please call Schank Family Law and we can answer any questions that you have.